Welcome in, everybody. Before we get started, please like, subscribe, and hit the notification bell. You know, all the YouTubey things. Forget what you think you know about justice. Welcome to the Virtual Juror, where snark is reality, but evidence is royalty. Where at first we look at the FACS, or Facts and Conjecture Shared, before we get into the real stuff. Welcome to the most recent chapter of this legal swamp, and trust me, there's plenty of gold to mine in the rest of 2025. The year kicked off with the defense trying to erase some of the most embarrassing evidence. In January 2025, a significant evidentiary hearing was held because they desperately wanted to suppress evidence, particularly certain communications, which included an actual letter found in Kouri's jail cell. You know things are going poorly when your lawyers have to argue that a note you wrote while incarcerated shouldn't be used against you. But if you don't want the court to see your jailhouse letters, perhaps don't write them. It's the legal equivalent of arguing that a diary found under your mattress is protected by the First Amendment. Law enforcement and the victim's brother-in-law even had to testify at the subsequent hearing on January 29th, presumably to confirm that yes, the letter smelled suspiciously like prison paper and was in fact incriminating. Then came the bold gambit, or an everyone hates me motion, whichever you prefer, in the form of a change of venue. On April 7th, the defense argued that surely the fine citizens of Summit County were too informed, and therefore too disgusted, to be impartial jurors. The court, wisely realizing that finding a person anywhere in Utah who hasn't heard about this case may be impossible, denied the change of venue, insisting the trial stay put. In a move of glorious, expensive desperation, the defense asked for and got a stay so they could file a mid-trial appeal, an interlocutory appeal, with the Utah Supreme Court. The trial was thus delayed indefinitely, which, let's be honest, was probably the real goal. Unfortunately for the defense, the Supreme Court was clearly in a hurry to get to lunch and uninterested in the drama. On April 24th, they unanimously rejected the appeal. They didn't just reject it. They essentially told the defense to stop complaining, ruling that the jury pool would be limited to Summit County only, and that jury selection could be done virtually, as normal. Take that, logistical complexity. That's right, the state's highest court decided this whole case wasn't worth the gas money for a new jury pool. The civil suits, meanwhile, were a hot mess. On May 14th, the court ruled on a flurry of motions. First, the deposition dance. Kouri successfully managed to postpone her civil deposition until after June 2nd, 2025. However, the court denied her request to delay it until a final resolution of her criminal charges, i.e., until after all appeals are exhausted. The court basically said, "We'll give you a small break, but we're not waiting for the inevitable decades of appeals. You can't run from the money questions forever." Second up, consolidation. A motion to combine the various civil cases was denied, with the court citing different procedural postures. That's legal speak for we can't even tell what's going on with all these lawsuits, so no. Next was terminating sanctions. The court decided that since Kouri was a no-show for her prior deposition before the stay was granted, she was on the hook for attorney's fees. She may be fighting for her freedom, but even then, because of her bad attendance, she's still responsible for those billable hours. Just when you thought the indictment list couldn't get any longer, the prosecution decided to give the defense a belated summer gift. On June 27th, they filed an additional 26 charges, turning the entire case into a financial crime textbook, bringing the total count into the truly impressive range. We're talking 7 counts of money laundering, 6 counts of mortgage fraud, 7 counts of issuing a bad check, and 5 counts of forgery. Because apparently a spectacular murder allegation wasn't enough to capture her entire alleged fiscal portfolio. Clearly, if you're going to commit alleged crimes, you should go for bulk. In a small bit of common sense, the court ordered on August 1st that the murder and financial charges be tried separately. No jury could possibly handle all that melodrama in one sitting. The scheduling conference on August 4th immediately descended into chaos. The prosecution filed a lengthy motion because the defense attorney had the audacity to subpoena the Richins family spokesperson. The spokesperson. The person whose only job is to stand outside and look sad while reading a prepared statement. The prosecution was so offended that they asked for sanctions against the defense attorneys and a referral for ethical violations. Because nothing says we're desperate like dragging the poor person who must talk to the media into the witness box. It's the legal equivalent of tattling to the principal over a silly note. But it worked, showing that in this case, even the family PR person is scared. Despite all the appeals, all the new charges, and all the ethical snitching, a date has finally been set. Jury selection is scheduled to begin on February 10th, 2026, with the trial starting on February 23rd, 2026. The moral of this chapter? Kouri's legal team is aggressive. Her alleged crime list is long enough to cover 2 separate trials, and the Utah Supreme Court thinks they should just hurry up and get the show on the road. The defense is trying every trick in the book to keep the charges from multiplying. Do you think the defense has any more ridiculous Hail Mary motions left in them before February 2026? Either way, 17 months later, at least there's a trial date. Well, that's all we have. So as always, love your family, love your pets, love your neighbors, and we'll see you next time.
Whispers loud, where do I begin? One road to mercy, one road to pain. Every choice here leaves a blood.